Welcome back to the deep dive. This time, you've really tasked us with something pretty demanding.
You can say that again?
We're taking this mountain of high-stakes legal and political testimony, and, well, we're going to try and distill it down to the essential insights for you.
That's right. We are diving deep into the transcribed deposition of former Special Counsel Jack Smith. This was before the House Judiciary Committee on December 17th, 2025.
And this document it's really a singular record. You've got the special counsel defending his entire work under oath, facing just intense political scrutiny.
Exactly.
So our mission here is to cut through all of that noise.
Yeah.
We want to pull out the key legal restrictions, what Smith could even say, the principles he claimed guided him, and of course, the actual evidence he laid out.
And you have to understand the setting. This was not some friendly chat.
Yeah.
It was requested as part of the committee's oversight into the so-called weaponization of the Justice Department. Smith is under oath. He's got his counsel there, Peter Kalevsky and Lanny Breuer. He's there to answer for everything.
And the tension, you can feel it from the very beginning. Smith actually wanted this hearing to be public.
He did. He said he wanted to correct, and this is a quote, the false and misleading characterizations of his work.
But the committee chairman denied that.
Denied it. Insisted on a closed-door deposition.
Which immediately put some major constraints on what he could talk about.
Oh, huge constraints. And you really need to get this to understand the rest of the testimony. First, you have Federal Rule of Criminal Procedure 6E.
Grand jury secrecy?
Exactly. Grand jury secrecy. This is how prosecutors get their most sensitive evidence. And Rule 6E basically forbids them from talking about what happens in that room, who testified, what they said, what was presented.
So a lot of the details they're off the table from the start.
Completely off the table.
Okay, so that's one. What was the second major constraint?
The second was a very specific court order from Judge Cannon, the judge in the classified documents case. She'd issued an injunction back on January 21, 2025, and it prohibited any public disclosure of the information or conclusions in what's known as Volume 2 of the Special Counsel's report.
And just to clarify for everyone listening, Volume 2 isn't the indictment, right? It's something different.
No, it's totally different. When a special counsel finishes their investigation, they write this big internal report for the Attorney General. Volume 2 was the part of Smith's report that was all about the classified documents investigation.
So the judge's order basically gagged him from talking about his own final report on that case.
Pretty much. He couldn't publicly discuss his findings on the Florida case outside of the actual court proceedings. So, he's testifying with one hand tied behind his back.
A closed room, under oath, and legally boxed in. It's not exactly the ideal place to correct the public record.
Not at all.
Okay, so with all that in mind, let's unpack his core defense. He really leaned on his professional resume, and I have to say, it is impressive. We're talking nearly 30 years as a prosecutor.
Yeah, from Manhattan assistant DA all the way to a war crimes prosecutor in The Hague.
And that history was his anchor, right?
It was his whole argument. When the committee kept pushing this weaponization angle, Smith's counter was always his commitment to integrity. He kept repeating this principle, follow the facts and the law, and to do so without fear or favor.
And he went further to try and head off the political attacks. He said he would brought the same charges against any former president, quote, regardless of whether that president was a Republican or a Democrat.
He was really insistent on that. He said he didn't have a preconceived outcome when he started. And what's so fascinating is how he grounds this defense in, classic prosecutor ethics.
He's trying to move it out of the political arena.
And into the legal one. They even questioned him about that famous quote from Attorney General Robert Jackson.
Oh, the one about the most dangerous power of a prosecutor is to pick the man and then searching the law books to pin some offenses on him.
That's the one.
And Smith agreed with that standard.
He did. And by agreeing, he's not just, nodding along to some old quote. He's implicitly telling the committee, I did the opposite of that.
That he found the facts first, and the facts led him to the man.
Exactly. Not the other way around. It's a really high bar defense against a political targeting charge.
Okay, that's a powerful way to frame it. So let's shift from the philosophy to the actual cases. Let's start with the election interference case. Smith was pretty definitive about the strength of their evidence.
He was. He stated his office had proof beyond a reasonable doubt that Trump was part of a criminal scheme to overturn the results of the 2020 election.
That's the core of it.
That's the core legal claim. And he really drilled down on their strategy, why focus so much on Trump himself. Smith argued he was by a large measure, the most culpable and most responsible person in this conspiracy.
Because the crimes were committed for his benefit.
For his benefit, period.
And this is where the evidence he presented gets really sticky for the other side. Smith pointed out that his key witnesses weren't Trump's political enemies.
Not at all. They were his political allies, people who voted for him, campaigned for him. These were not hostile witnesses.
Right.
No, the credibility of the whole case was built on Republican state officials, people like the Arizona Speaker of the House, who gave these detailed accounts of the pressure Trump put on them directly.
And Smith had a specific way of framing that pressure.
He did. He said Trump was preying on the party allegiance of these officials, basically using their loyalty to him and the party to try and get them to break the law.
So the committee must have pushed him hard on the co-conspirators.
Yeah.
Figures like Rudy Giuliani, Kenneth Chesebro, Boris Epstein. Why weren't they charged with Trump in D.C.?
They did, and he had a two-part answer. First, he confirmed that his office was looking at prosecuting them.
Okay.
But he said they hadn't made a final decision when the special counsel's office started closing down, which, he pointed out, was because Trump won re-election.
So that sort of makes the question of future prosecutions a bit moot.
For now, at least.
Yeah.
But then he gave the tactical reason.
Which was?
He basically said the case had so much evidence against the former president that they had to streamline it. Just a fire hose of witnesses and documents. Adding a bunch of other co-conspirators would have made the trial incredibly unwieldy.
Confusing for a jury.
Potentially, yeah. It was a strategic choice to bring the sharpest, most direct case possible against the person they saw as the main actor.
I see the logic there, but it does open them up to criticism, right? That they just let these other key players off the hook.
It's a fair point, and Smith's answer really focused on efficiency. He wasn't saying they were innocent. He was saying the evidence against the principal was so overwhelming that their priority was to get a verdict on him first.
So the strength of the evidence dictated the narrow focus.
That was his argument.
Okay, we also have to talk about the call records. The acquisition of records for members of Congress and senators, that was a huge controversy.
A huge deal. And Smith defended it completely. He was very careful to clarify they sought toll records.
Right, which is crucial. This is non-content data.
Exactly. It's the envelope, not the letter. It just shows you who called, who, when, and for how long, not what they said.
But why the non-disclosure orders? The NDOs. Why hide the fact they were even looking for these records?
His answer was blunt. A grave risk of obstruction of justice. He tied it directly to the obstructive behavior they'd already alleged in the classified documents case. He believed if these people knew their records were being pulled, evidence could be destroyed or witnesses could be tampered with.
And he had a pretty strong counter-argument to the charge that they were just targeting Congress.
A very strong one. He said his office didn't just randomly decide to go after members of Congress. They sought the records because they had evidence that Trump and his team were calling these members in furtherance of their criminal scheme, urging them to further delay certification.
And then he had that killer line.
He did. He said, very simply, "I did not choose those members, President Trump did." The investigation just followed that trail.
Okay, that definitely clarifies the rationale. Let's pivot now to the classified documents case, the one that was so constrained by Judge Cannon's order about Volume 2.
Right. But even with those constraints, Smith was able to summarize the main allegations from the indictment. The core of it was that Trump willfully kept these highly classified national defense documents after he left office.
And stored them at Mar-a-Lago, his social club.
Which is just. The factual context of that storage is alarming. The deposition brings it up again. You've got top-secret documents stored in a ballroom in a bathroom.
In a club that hosted, over 150 social events?
150 social events, tens of thousands of guests coming and going. The security implications of that, they're just staggering. You have staff, vendors, international guests. It's a nightmare scenario.
And then there's the other half of that case, which is the obstruction narrative. The deposition goes into the steps taken after the subpoena was issued.
It does. The indictment alleges that after the grand jury subpoena landed, 64 boxes were moved out of the storage room.
Before the lawyer searched it.
Before his own attorney conducted the search to comply with the subpoena, and then only 30 boxes were brought back. It just screams concealment.
And the most direct piece of obstruction evidence involved the security footage.
A very serious claim. The evidence pointed to specific directives from the top. Smith confirmed they had evidence that Trump directed his co-conspirator, Carlos de Oliveira, to go ask an IT employee to delete the security camera footage.
With an explicit message.
A very explicit message.
Yeah.
That the boss wanted the server deleted. That level of direct involvement in what looks like evidence tampering is it's incredibly damning.
And in the end, the FBI searched the property in August 2022. Smith made a point to defend the legality of that search during the deposition.
Yeah, he noted that Judge Cannon, actually later denied a motion from the defense that challenged the probable cause for that warrant.
So the legal basis for the raid was upheld by the court.
Which really speaks to the strength of the evidence they must have presented to get that warrant in the first place.
So you had these two cases, which the special counsel argues are legally sound, built on facts and high ethical standards. But what was the cost? This is where we need to talk about the political pressure and the alleged retaliation against Smith and his team.
The deposition really paints a picture of a team that was operating under siege. When he was asked why he sought gag orders in the D.C. case, Smith was not subtle.
He was pretty blunt.
He said he sought them because Trump was making statements, endangering witnesses, intimidating witnesses, endangering members of my staff, endangering court staff.
He gave some chilling examples.
He did. He confirmed that the judge presiding over the D.C. case received vile death threats, and that the Court of Appeals, when it upheld the protective order, specifically found Trump's statements would chill witnesses who had not yet come forward.
He said he made no apologies for it.
None. He said his job was to protect the process. But the retaliation went beyond threats. It became professional. Smith confirmed that more than a dozen career public servants,
Federal attorneys, FBI agents.
the people who worked on these cases for years, they were fired after Trump won re-election, often with no real justification given.
And the retribution even targeted his own defense counsel.
That's right. He explained how the lawyers representing him, from the firm Covington and Burling, had their security clearances suspended by an executive order in February 2025.
And his interpretation of that was?
He stated it plainly. He said it was meant to chill people from having an association with me, to make it politically toxic to work with him.
There's that powerful moment where his counsel responds, "Still here, proud to represent Jack Smith."
That's a striking moment. It really highlights the personal costs involved.
And the final piece of this was about the presidential pardons.
Yes. Smith confirmed his understanding that pardons were given to people who had violently assaulted police officers on January 6th. He mentioned people sentenced for inflicting serious injuries, even causing heart attacks.
And when he was asked if pardoning people who attack law enforcement makes the country safer, his answer was simple.
It does not, in my view. He even noted that some of the people who were pardoned had already gone on to commit other serious crimes. It just speaks to this breakdown of accountability.
So when you pull it all together, the deposition really highlights this profound dichotomy.
It really does. On one side, you have this career prosecutor defending his team's integrity, insisting they moved fast because, as he said, the timing and speed of our work reflects the strength of the evidence.
And on the other side,
An incredibly intense political counterattack, a closed-door hearing, threats against judges and staff, and the systematic firing of the people who actually did the work.
So I think the ultimate takeaway for you listening to this is the special counsel's conviction, which he stated under oath. Despite all the pressure, all the retribution, Smith maintained they followed the law, they built two strong cases, and the prosecution was based purely on the facts.
And this dive into the transcript leaves us with a really critical question, one that gets at the long-term health of our legal system. If individuals who violently assaulted police officers on January 6th are pardoned, and the career federal prosecutors and FBI agents who investigated those exact crimes are then fired without cause, what is the clear, long-term message being sent?
A message to every federal law enforcement officer.
Every single one of them. What is the message about the personal risks of upholding the rule of law when a case becomes politically sensitive? And that's something for you to mull over long after this deep dive is over.